So I have an important update in the current lawsuits against the ATF and their whole pistol brace rule, which expanded the definition of what an SBR is. And this is going to be also an update on the nationwide vacature of that rule. So let's break down now what is happening. Now, really quick before we jump in this video, I want to thank one of the main supporters of this channel, which is Kershaw Knives. Kershaw makes amazing knives. I love their knives. I actually spent some time out in their factory out in Oregon. I got to see how they make them. And also they told me they make about 500,000 American-made knives out of that one factory every single month. So if you just want a quality EDC knife, check out Kershaw Knives. And if you use the code ARMED40, you can get 40% off of your order. So like I mentioned in the intro, I have some important updates in the ATF pistol brace and SBR expansion rule with all the cases that deal with pistol braces and the current nationwide vacature that is currently in place protecting your possession and use of pistol braces. The ATF has been suffering major losses in various cases, and now even more so since the Supreme Court issued their decision in Cargill striking down the ATF's bump stock rule. Because of this, the ATF has been scrambling to figure out, what they can do and what they're going to do with some of these lawsuits because they keep losing. And now the ATF has decided to appeal the recent decision of the lower court from Judge Reed O'Connor, striking down the entire rule, vacating it nationwide, and that was a final merits decision issuing a motion for summary judgment in favor of the plaintiffs. So this is one of the most important cases now that has been appealed up to the Fifth Circuit, and the Fifth Circuit is going to review the final merits decision which struck down the pistol brace rule nationwide. You may recall that recently with the pistol brace lawsuits, Judge O'Connor in the lower court reviewed the Mock versus Garland case, that's a case we're talking about, and he issued a final merits decision. He granted the plaintiffs their motion for summary judgment, which struck down the entire pistol brace rule nationwide and found that it was invalid. Now, in this decision, Judge O'Connor stated that at the conclusion of the majority's careful analysis, they held that the final rule is properly characterized as a legislative rule and is relatively straightforward that the final rule was not a logical outgrowth of the proposed rule. Therefore, the final rule must be set aside as unlawful or otherwise remanded for appropriate remediation. And based on that, he granted the plaintiff's request for a motion for summary judgment. So that was FBC and some other individuals like Maximum Defense granted their motion for summary judgment, striking down the entire rule nationwide. And it was a nationwide final merits vacature of the rule. So that was a huge win. And that's really what's protecting everyone nationwide. That decision essentially overrides the limited preliminary injunctions which were issued, kind of overrides them in importance. And we knew that the ATF was going to appeal and ask for a stay, and that's exactly what they have now done. They want to put that nationwide vacature on hold, and they want to be able to appeal that decision. Now, one of the important things you have to keep in mind when it comes to the decision from Judge O'Connor, and also some of the other decisions that are kind of playing off of this mock decision, is the fact that this is not purely a Second Amendment case, so it's not a challenge to the pistol brace rule based on Second Amendment grounds. There are some Second Amendment arguments that were made in this lawsuit, but the primary decision was based on the APA, also known as the Administrative Procedures Act. What Judge O'Connor found is that the ATF deviated too much from the proposed rule to the final rule. So when it comes to the APA and these types of rules, when the ATF is promulgating these rules, they have to have a proposed rule and they have to have a commenting and notice period. That's exactly what they did. And in the proposed rule, they had the worksheet 4999. And the worksheet 4999 had a point system. It was a little bit more express about how you would look at a specific characteristic of a firearm. Look at it. Does it have a brace on it? What length is it? What weight is it? What accessories does it have on it? And then you would add up points based on all that. And if you reached a certain point threshold, well, then the ATF would say that that item is actually an SBR. And what the ATF did is instead of addressing those issues in the final rule, they just completely scrapped the worksheet and then went to an even more vague and arbitrary process where they had some 6 factors where they would say if there's certain surface area that you could maybe shoulder, that would qualify it as an SBR. And if you looked at other 6 factors like community use of the item and marketing, well, then that could also help the ATF determine whether or not something with a brace on it is actually an SBR. Now, all of that also in the final rule just gave a lot of discretion to the ATF because they had catch-all provisions where they said, these are some rules, but this is not all inclusive. And we retain the ability to still say something that doesn't meet these requirements is still an SBR. And it's because of this drastic shift from the proposed rule to the final rule that made Judge O'Connor find that this was a violation of the APA. Now, what's also interesting in this specific lawsuit dealing with mock is the fact that the ATF is also trying to use the Rahimi decision, the 8-1 decision from the Supreme Court, to support the restrictions here on braced pistols and, treating them as SBR. So they're trying to pull in that Rahimi decision to support what they are now doing with their rule. They argue that under the facial challenge analysis in Rahimi, this case should in fact be sent back down to Judge O'Connor for a new analysis, and that the Fifth Circuit should find that they don't need to review this issue, but instead Judge O'Connor should have to reissue a new decision in light of Rahimi. In the letter, the ATF argues that Rahimi made clear that to establish that a regulation is consistent with the historical tradition of firearms regulation, the government need only show that the challenged regulation is consistent with the principles that underpin our regulatory tradition, not that a law precisely matches its historical precursors. The government has identified the historical principle that bears on these appeals. The Second Amendment permits disarmament of instruments that constitute bearable arms that are not typically possessed by law-abiding citizens for lawful purposes. That limitation is consistent with the historical restrictions on dangerous and unusual weapons. The ATF also argues that under Rahimi's reasoning, plaintiffs' facial challenges to the rule and the NFA's regulations for short-barreled rifles must fail so long as those regulations are constitutional in some of their applications. So again, you have the ATF arguing that Rahimi and the historical analysis and some of the facial challenge issues need to be relitigated and analyzed by Judge O'Connor before this final merits decision is actually, left in place. Now, in many ways, this type of argument is what Justice Thomas was concerned about when he was the only dissenter in the Rahimi decision. You may recall that, of course, Thomas was the author of Bruin, and Thomas was very concerned about maybe this type of looser analysis plaguing some other cases. He stated that he wanted to probably keep the analysis in Bruin as tight and restricted as possible. He didn't want any wiggle room. And you're seeing the ATF trying to use that wiggle room to now say that any braced pistol is actually an SBR. So we were waiting for the ATF to make their decision, and they have now decided to appeal this case, appeal the mock final merits decision to the Fifth Circuit. They are appealing that, and they're also going to seek a stay of the lower court decision. Now, also, when you look at the landscape of all the pistol brace cases, you still have limited preliminary injunctions that are in place, not just the ones that are in place where you have, the other mock decision, the Brito nationwide preliminary injunction, some of the other ones as well. Those are currently set to be reviewed by the Fifth Circuit, I believe, in September. But I would anticipate now with this appeal, the final merits decision, probably some of those are going to be consolidated or maybe even put aside for review of this issue on the final merits. Also, you recently had the 8th Circuit, a 3-judge panel in the 8th Circuit that also ruled that the pistol brace rule by the ATF is in fact a violation of the APA. They struck it down. They said that the plaintiffs were likely to succeed on the merits, and they sent the case back down to the district court, the lower court, for a decision on what scope of relief should actually be granted. So you have wins out of the 8th Circuit and then also multiple wins out of the 5th Circuit. But when it comes to the greater landscape of the importance of all the cases, I think this appeal here of the final merits is the most important, because this is the one that is going to make its way fastest along the process. And this is the one that's going to be appealed in the 5th Circuit, reviewed by the 5th Circuit, probably go en banc, and eventually also probably make its way to the Supreme Court, like all the other cases that have currently made their way to the Supreme Court, like the Cargill decision and the Vanderstock frames and receivers rule that is set to be decided during the Supreme Court's next term. So that's what's going on with pistol braces. That's where the pistol brace lawsuit landscape currently stands. And now we're going to wait to see what happens in the 5th Circuit, how some of these procedures shake out, and what the 5th Circuit decides they want to do with some of these lawsuits. And I suspect that there's going to be arguments on the stay request from the ATF, and of course, arguments on the final merits decision from Judge O'Connor. So if anything changes, I will let you guys know. Also, if you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.